Good afternoon, and thank you for joining us today. I would like to welcome you to Fortney Scott's special webinar titled Federal Contractors' New DEI Obligations. This webinar will be recorded. Today's presenters are Fortney Scott attorneys Elizabeth Bradley, Nita Beecher, and Sarah Mugman. I will now turn the program over to Nita to start the webinar.
Hi, everyone. Great way to start a Friday morning. Last Friday, we got a brand new DE&I executive order, which the three of us want to talk about in some detail. So let's go to the next slide. As you all know, this is Fortney Scott. We are a Washington, D.C. law firm. This is exactly what we do, what we're going to be talking about. And we will be doing a podcast on this probably later this week. So stay tuned to listen to the podcast with David Fortney and other of our attorneys. All right, let's get right to it. We got a bunch to cover here. So let's go to it. Yes, we now have an executive order number. This is 14398, addressing DEI discrimination by federal contractors, which was actually issued on March 26th, which was Thursday. We're going to go through the executive order in detail, talk about policy and purpose, the definitions, mandatory contract provisions, who has to do what to whom as agency mandates, and then legal considerations, because as we know, 14173, the predecessor to this executive order, has been under intense legal scrutiny by the courts across the country. Finally, we want to give you some takeaways and next steps for you to think about. I mean, there's a lot to still unpack about this, but we're going to give you sort of our highlights as we see them so far. And with that, let's go to the next slide, and we're going to kick it right off. So Liz, you want to kick it off for us with the key provisions in this new executive order?
Yeah, starting on the next slide, we're going to kind of grounding us back, a little refresher, reminder of what 14173, the framework that is sort of the foundation of this new executive order. If you recall, the purpose of 14173, titled Ending Illegal Discrimination, Restoring Merit-Based Opportunity, the stated purpose of this initial executive order was to enforce the federal civil rights laws by ending illegal preferences and discrimination. The executive order revoked Executive Order 11246 that required affirmative action by contractors for women and minorities. It also directed government agencies to eliminate DE&I within the federal government, took action to discourage private sector from engaging DE&I, and kind of specifically as part of that, it directed the development of an egregious and discriminatory DE&I practitioners list that was compiled and sent up to the White House. And importantly, the 141 included a certification provision required say that federal contractors were in compliance with federal anti-discrimination laws and did not have any DE&I programs that violated federal anti-discrimination laws. So going back to 14173, it was grounded in existing federal laws and Title VII and the other laws. So if we move into looking at what the current executive order policy and purposes is on the next slide, it's interesting. So it reaffirms the administration's policy against DE&I, and it asserts that DE&I is impeding merit-based decision-making, easy for me to say, and it makes a reference to illegal DE&I practices. But if you review the new 14398, there's no mention. It is void of any reference to federal civil rights laws or federal anti-discrimination laws. It makes the vague assertion of illegal without defining what it is, what laws they are illegal under. And rather, now this executive order is saying it is the policy of the United States to promote economy and efficiency in federal contracting by preventing racial discrimination. So Nita, I know you have some thoughts on what is the impetus of the changed statement of focus.
One of the things is that these executive orders that are issued by the president, especially for federal contractors, are being issued under the Procurement Act, which we can talk about, but we're all familiar with the Procurement Act. And the presidents over the years have been issuing regulations like this under this particular under the Procurement Act. But under the Biden administration, when they issued a number of federal minimum wage uh, extensions, there were issues, there were numerous cases filed, and in the the Ninth Circuit held that the president did not have the authority to issue these kinds of executive orders because what the Procurement Act was all about was inefficiency, ensuring there's no inefficiency, fraud, or waste in the federal procurement. So I believe that, as we've talked about amongst ourselves, that's why we have this specific language to try to avoid the Ninth Circuit in particular deciding that this executive order violates the Procurement Act and can't be issued.
And Sarah, so what's some of the language? There's some pretty direct language in the executive order that is focusing on this inefficiencies and waste.
Exactly. So the executive order itself kind of lists out how certain DEI activities taken on by federal contractors can ultimately be passed along to the federal government. And the purpose is to decrease those costs and to increase efficiency. So it lists a few examples of how these activities could increase costs. So one, the order asserts concerns about employee turnover. So essentially suggesting that when performance kind of takes a back seat, that the organization could see higher turnover and then have increased costs that come along with more frequent recruiting and training because of that turnover. Beyond that, the order also notes that workplace effectiveness can suffer if DEI practices kind of disrupt collaboration or problem solving amongst teams. And finally, it asserts that narrowing hiring or promotion criteria may actually reduce the overall talent pool. That's going to make it harder for efficient identification of the most qualified candidates. So really, it's framing this executive order as directly relevant to the administration's objective of ensuring cost efficiency and cost effectiveness and efficiency in federal procurement.
And I just kind of a little commentary on this. It seems to be framing that DE&I is resulting in lower quality hires, and it's going back and beating the drum on merit-based decision making, and that DE&I has infringed on that, and that's just sort of the baseline of this administration. Mm-hmm. So moving on to sorry, Nita, you have something to say?
I was just going to say, I agree 100% with that's how they're tying this DE&I push back to the Procurement Act.
So moving on to the definitions, and there is a lot to unpack here. And so we're going to kind of tag team through this. But here's a direct language out of the executive order. And this definition section is incredibly important because when we go into talking about the certifications, you're certifying compliance with this definition of what is allegedly racially discriminatory DE&I activities. This is sort of the linchpin of all of it. First of all, it is limited to disparate treatment, which we expected. We know this administration has moved away from disparate impact theory. Mm-hmm. So it is programs of disparate treatment based on race or ethnicity. Notice what is missing here. This definition does not include sex. And so kind of, Nita, I know you have some thoughts on, I would first like to highlight eliminating sex is different than what we have seen from memos from the AG, memos out of the EEOC. They all have been consistent in including sex in their definitions of unlawful DE&I. But Nita, what are your thoughts here on why sex has been removed from from this definition?
Well, it is an interesting question, but what I will say is that the GSA just issued a proposed regulation for grantees as opposed to federal contractors, which would change the certification language in the SAM database, which contractors have to enter into and certify various kinds of things. And as to that, it will ask federal grantees to certify they will comply with laws prohibiting unlawful discrimination based on race or color. And in other places, it says race or ethnicity. And so at some point, obviously, the administration decided to drop the challenge to sex, at least in this point, and focus primarily on race discrimination, and agreed that the disparate treatment aspect of this is because disparate impact has been disallowed by this administration, even though it's still in Title VII.
With that being said, though, I do think everybody needs to be mindful, even though this is drafted to say race and ethnicity, it's still a wait and see. And I do think that women are still protected under the federal anti-discrimination laws. So, it's not a green light to engage in, right? The next piece of this we're looking at is it's clear disparate treatment in recruitment, employment, hiring. That we got, and that's pretty consistent and standard. So didn't highlight it here because that is a consistent point. One thing I want to highlight here is the contracting, disparate treatment based on race or ethnicity in contracting vendor agreements. This is supplier diversity. We've known this administration has concerns about supplier diversity programs. They want to go after those. Now that they've put this into the definition section, making that you are not engaging in sort of disparate treatment in your supplier diversity program is going to be part of the certifications. So we're going to be talking about some best practices to address that later on. We also have program participation. So program participation is they've also added a definition of program participation. This is looking at disparate treatment in membership or participation, access to training, mentoring, leadership development programs, educational groups, clubs, associations. These are your ERGs. This is really highly focused, I believe, on ERGs. And even though I think often we are looking at our ERGs and everybody's done, I'm hoping everybody out there has looked at their DE&I programs and made sure your ERGs are open to all. I still think we need to spend a little bit more time focused on those and looking at the potential impact and how this executive order is going to be looking at facing those. Nita.
I think this also, and whether they can actually do this is another issue, but both on the allocation or deployment of entities' resources or sponsored or established by the contractor or subcontractor, are they going after all of these organizations that corporations support that support various kinds of race groups? Just an example, because I work for McDonnell Douglas. We had the Hispanic engineers convention every year. We had the Black engineers every year, obviously women engineers as well. Are they implying or attempting to stop corporations from providing monies? Because without the monies, in fact, we know recently the DE&I organization that did the Mansfield certification is basically, it has no money, and so it's going to go out of business. And that's the kind of thing that, yeah.
I think that's exactly, I do that. That was, the next thing to be thinking about here is how are you allocating and setting aside whether there's any legal basis to challenge this. Right. What is the legal basis for the government to tell a corporation how they can and cannot spend corporate resources that are not directly from the federal government or even indirectly? So there's that pause point on the legality of this provision and likely to be challenged. But what are you sponsoring? Where are you putting those resources? We need to be going back and thinking about that. And I think often when we were doing our DE&I assessments, we were looking at program employee related, thinking, how your charitable donations likely are not going to be the focus of this administration. I think that we need to be rethinking that and refocusing and looking at those donations and those sponsorships and see how you're spending allocations. Yes, Nita.
Liz, even if there are plenty of, the First Amendment, for example, allows corporations to spend the money. They have in the past, the corporations have in the past had the federal government tell them they can't use federal monies for some of these things, right. In particular, supporting anti-union activity, as I recall. But I think this really is a risk assessment for each corporation. What kind of risk are they willing to take, and what this means.
I also have to believe there's going to have to be some clarification, whether that happens through broader FAQs or if it happens through legal challenges. But these are pretty broad statements because we're going to get to moving on to the next section. And Nita, I'm going to turn it over to you, but we're now talking about what you're going to be certifying. So the next 6 bullets are statements that are going to be placed into your contracts and you're going to be certifying that you are in agreement with. So Nita, why don't you lead off with the first 2?
Sure. The first one is obviously that the contractor will not engage in any racially discriminatory DE&I activities as defined in Section 2, which we just discussed. What I think is really interesting about this is that it doesn't say anything about unlawful under Title VII or the ADEA, or fill in the blanks.
Anti-federal Civil Rights Act laws, no.
None of that, which I find to be fascinating. But that's why they have a definition, which interestingly, not having a definition in 14173 was creating problems in litigation for them, which is, I think, one of the reasons they put a specific definition in. But I think the second one is even tricky.
I will just chime on that. I think you're right. They were trying to cure that with the definition, but I think their definition is so vague that I think it could be subject to challenge. I just, 2 days in, but here we go. So sorry, Nita, go ahead. Number 2.
I think much of this is subject to challenge and will be challenged, and we can talk a little bit later about how we think it'll be challenged. The second bullet here is that contractors will furnish all information and reports, including providing access to books, records, and accounts as required by the contracting agency. So it appears that there will be developed in the agencies from whom you get your contracts, a unit, which used to be OFCCP, but no longer would be, I presume, that there would be a unit which will tell you, we're going to come and look at your books and records. And this would be for purposes to ascertain that they are in fact in compliance. There are a couple other things it says is you better be doing analysis of your hires and promotions and layoffs to make sure that you are not discriminating. You need to be assessing your complaints to ensure that you're not going to, that you're handling complaints by various individuals, white individuals perhaps, who claim that they have been discriminated against based on DE&I, which could then lead to other problems. But this requirement, and we just don't know how that's going to play out. But Liz, Sarah, what do you think?
Well, I think one thing that contractors need to be prepared for is this is now going to be, as it seems to be written, each contracting agency is going to have its own investigations and audit practices. They're going to be different based on each organization. What data is all information? How broad is that from this agency to that agency? I think it's going to be a bit of a mess for a while. And I think, but I don't know. I mean, maybe this is why OFCCP was fully funded. I don't know what we don't know what OFCCP was fully funded for, but I think it's going to be a challenge in order to have a structure to your auditing practices going forward. So
one last thing, and then I'll turn it over to you, Liz. But one last point I wanted to make about this is that prior to 1978, this was how OFCC was like an agency that managed other agencies that did this kind of work. And in 1978, they said, nah, this is not working. And they sent it all to OFCCP. So Liz, you're up.
Maybe it's some old is new again, I guess, is the saying there. So the third provision, and again, this is not new, but you are now certifying clearly and directly that you agree that your non-compliance with this clause, and it's back to the Section 3 definition, not federal anti-discrimination or civil rights laws, but that you're saying that failing to comply with the provisions of this executive order may result in your contracts being canceled, terminated, or suspended, whole or in part, and you being barred from further government contracts. So this is, again, it's making sure contractors are aware of this. We're going to also see where OMB is being directed with regard to this provision to start using these penalties more. I mean, I think in our OFCCP compliance landscape, when contractors were not in compliance with the 11246 obligations, we rarely saw contracts being canceled, terminated, suspended. I think this is a penalty that's going to start being used by this administration. So we need to be aware of it. I think it's very important. Number 4 is another one. You are now certifying that you will report any subcontractors' known or reasonably knowable conduct that may violate this clause. So if you receive information that one of your subcontractors may be in violation, you don't even have to confirm that they are. You now have a reporting obligation to turn in that subcontractor. Mm-hmm. This is a big deal. This is and what is going to be sufficient knowledge? Something we don't know. What is reasonably knowledgeable? Are you going to have to be putting in some sort of steps in order to monitor your subcontractors' compliance, sending them out so they at least have to send out to your subcontractors, execute this for us, saying that you are in compliance, so that you have those records in the event that the government comes to you under subpart 4, and at least you can say, well, they certified to me that they were in compliance. Likely, I mean, we're going to probably have to put something in place to protect contractors' primes and any subs who have subs, so that you don't have knowledge of alleged violations. So this is a piece I think everybody needs to be thinking about a little bit.
Liz,
in
prior life, they did actually there was a requirement, not quite as specific as this, that and I remember, having to certify as a sub to the prime that you were in compliance. I think this goes farther personally.
This does go farther, but again, needed to the one before. This is a little bit of the old is new again. So there was this compliance obligation before. They're putting it back in place or highlighting it again, but I think they've gone further. Yes. So Sarah, do you want to talk to us about the next 2 sections?
Sure. So we've got another kind of new notice obligation on prime contractors. And this is in the 5th provision, which is going to it's specifically requiring prime contractors to inform the contracting agency if a subcontractor initiates a lawsuit against the prime that could in any way challenge the validity of this new contract clause. And so from kind of a practical standpoint, of course, this is really a provision about transparency and risk management for the benefit of the federal government. And the purpose is so that they can monitor this litigation as it develops.
Potentially intervene.
And when appropriate, potentially intervene or defend. Do you think that there's anything else this clause could be used for?
I think it could be a bit of a blacklisting. Again, what is old is new again. Is this where we're going to be creating a list of any companies that dare to challenge the validity of this? Are they now going to be put on a list of companies to not be issued prime contracts and potentially prohibited from issuing subcontracts? I wouldn't be surprised to hear that. Yeah.
And it falls in line with the 14173 also having a list. Lists seem to be a recurring theme.
Yeah.
I was just going to mention, what if you fire one of your minority contractors because you're concerned that they were selected because they're a minority contractor as previously required, and so you terminate them as a result of the executive order, and they sue you? Could that be
you're going to have to report that? You report that. Yes.
Exactly. And then we'll get to this 6th provision here, because this is really what's raising the stakes. Not only have we discussed these contract clauses that could result in, remedies under standard contractual law, but here they're also adding potential liability under the False Claims Act. Again, not entirely new compared to 14173, but what this is doing here is going to strengthen the materiality element of an FCA claim. So just by way of brief background, of course, liability under the False Claims Act can arise when a recipient of federal funds knowingly and falsely certifies compliance with a contractual requirement, with a statutory requirement, with a regulation. And that compliance is a material condition for the government to make payment on that claim. So that's kind of those elements. So that materiality piece comes up. Now, importantly, there was a case in 2016 at the Supreme Court where Justice Thomas, on behalf of the court, holds that merely labeling compliance as material isn't enough to kind of create that materiality, to meet that standard of materiality under the FCA. Rather, the government has to show that it actually would have refused payment had it known of the contractor's non-compliance with whichever requirement as issue. So here, this order appears to kind of address this materiality standard directly, first by kind of building that record, tying compliance of this new contract clause to cost and efficiency concerns, right? That's kind of the first piece. But then goes beyond just simply declaring materiality and instead really prescribes these concrete consequences that we just discussed. A contracting agency could potentially terminate this contract if non-compliance is found. And that really signals that the government would indeed not or would refuse payment if there's non-compliance. So that's how it's strengthening this potential liability under the FCA here.
I think that's absolutely right. So it does raise that as an issue.
Absolutely. So we're going to turn it over, Nita. Now we're going to start talking into how are the provisions of this executive order actually going to be implemented and some of the mandates that are being placed on the various agencies that are needed to get this rolling. So the next slide, please, Nita.
Yep. All right. So in section 4, we were just talking about section 3. That's all the very whereases and where-tos that the contractors will be certifying, and subcontractors, by the way. But now, after that, it says who's going to do what within the government, because the executive order then has to be implemented. In this case, OMB, first of all, is going to be issuing guidance that contracting agencies shall cancel, terminate, or suspend contract for noncompliance with the executive order, and shall suspend and debar for failure to comply. Interestingly, earlier in the provision, it says may. It does not say shall. So I do think that's kind of interesting. I don't know if that's intentional, but nevertheless. Anyway, the next thing which I find fascinating, so you've got OMB, you've got the Attorney General, you have the Assistant to the President for Domestic Policy, Stephen Miller, and you have Andrea Lucas, who's the chair of the EOC. They are together going to identify economic sectors that pose a particular risk of engaging in racially discriminatory DE&I practice based on current or past conduct. And we know, as you all were speaking earlier, that there has been a list put together, as we understand it, under 14173 of egregious DE&I practitioners. So I'm assuming that companies that were proudly proclaiming their DE&I programs and so forth may hear from the federal government on this issue. Finally,
I do not think.
go ahead.
I don't think the makeup of the group of people who are putting together the list under this executive order being essentially the same as those who were putting together the list over the prior executive order is by accident. And I am sure there's going to be some comparison of those lists in order to prioritize some enforcement. I can't help myself, but I have to call out the fact that this executive order that does not include discrimination on the basis of sex refers to the chair of the EEOC as chairman, which is not the normal nomenclature. It is chair of the EEOC. And of course, I did a little looky-loo. And the last time there was a male in the position of chair of the EEOC was back in 1997. So I don't know if this was a typo or something intentional, but it kind of jumped off the paper at me, but I can't help myself on that one.
Well, every time I've heard of her, I've heard her as the chair. And certainly the president, when he made her acting chair and then subsequently chair, described her as chair. But anyway, finally, the OMB is going to be issuing additional guidance to the contracting agencies on best ways to ensure compliance. And so I think it's important, though, they're going to be issuing guidance to the contracting agencies. And we're going to talk in a minute. And I think, Liz, you're up next with what the contracting agency mandates are, which include some of this regulatory obligations.
Absolutely. So the first thing that they're mandated on the next slide, the first thing that they're mandated to do is, to the extent permissible under the law, by April 25th, they are to ensure that the certification is included in contracts. That's the Section 3. So I know we talked a lot about when the prior executive order came out, and there were those 2 certifications. When are they going to roll out? We slowly started to see them trickle in via email, via text. I saw somebody come in through text. Okay, we're going to see a push of this. If you need to be in touch with your point of contact for each of your contracts that you have, that you are a prime contractor for, you are going to reach out from the contracting officer on each of those contracts. So if you have a different contracting officer on each contract, expect to get it in, and it's going to be from all kinds of different sources. That push is likely going to start very, very soon. The next deadline that the contracting agencies have is July 26th. And by July 26th, they will have completed a review of their implementation of the Section 3 contract provisions, getting their certification in, and they're going to report that up to the White House. So the same group that is getting the report that originally got the egregious DE&I report, who is getting the report of the sectors under this executive order, same assistant to the president of domestic policy is going to be getting this report from the contracting agencies about their implementation. So this is, again, you're going to be seeing these contract provisions, an initial push probably soon. We're going to talk about some of the other deadlines that may pause this until OMB takes a little bit more action. But by the end of July, you are likely going to be in a push where you have had to receive and execute these certifications. After July, there's an obligation that each contracting agency regularly review and take appropriate measures to make sure these provisions are in their contracts. What I'm reading this as a little frustration by the White House, probably, about the lack of getting the prior certification in. Now, granted, it was challenged legally, but a lot of the mandates that we're seeing on the federal agencies is more about, you need to get up and get this done, coming out of the White House.
Normally,
the next one is some attorney general mandates. Sarah, do you want to talk through those?
Yeah, sure thing. So that's the next slide, please. So unsurprisingly, of course, this executive order is requiring the Attorney General to coordinate with all the contracting agencies to consider bringing False Claims Act against contractors and subcontractors that allegedly violate this new contract laws. That goes in line with the provision and the list. There we go. They all kind of come together a little bit here. But what is also worth noting is that under the False Claims Act, it does permit private whistleblowers that are called relators to file QTM actions of alleged FCA or False Claims Act violations on the government's behalf. And so once a QTM action is filed, the government and the DOJ then, by statute, has 60 days to consider or to investigate and consider whether to intervene and take over that action. So what this executive order is calling for is for Attorney General Bondi to stick to that 60-day window or that statutory review period, because in practice, it generally takes months or years for that investigation to happen. And so this is very clearly directing the Attorney General to stick to that 60-day window rather than elongating that period, as often happens.
And again, I think this is the administration wants results under the FCA. They have been saying this since January of 2025 with the first executive order. This is, this is doubling down on that and trying to make sure there's results.
And they have that structure there too, because the Department of Justice has created task forces related specifically to enforcement of the FCA. So it's, again, it kind of falls in line with that.
We know that they're engaged in certain investigations because certain companies have received CIDs, which are a precursor to an investigation under the False Claims Act.
Yep. Yes. So Nita, do you want to talk to us about what the FAR Council is required to be doing?
So this is really important because, as we were talking about earlier, an executive order has to be implemented by the agencies. It's basically a direction from the president to the agencies telling them what to do. And unlike 14173, this is much more definitive about what they're supposed to do. This is a federal contractor, so it would be the Federal Acquisition Regulatory Council, or the FAR Council that as we know it, who are being directed to amend the FAR to include the certification that we talked about in Section 3, in solicitation and contracts, and remove any provisions that conflict with that or inconsistent with the executive order. I'm not sure they've actually removed the 141 or 11246 yet, have they, Liz?
I believe they have, or it's in the works. I know it came out of the SAM. The 11246 compliance came out of your SAM registration. But I think this second bullet here is really important. Remove any provisions that conflict or inconsistent with the EO. Going back to the definition of the EO, it calls out your vendor contracts, supplier diversity. The FAR still has provisions that require supplier diversity in federal contracts. Federal contractors are often stuck in a position of, wait a minute, you're giving me a new contract that has, or a renewal that has supplier diversity in it, but at the same time, you're telling me supplier diversity is a potential illegal DE&I. So the FAR Council has a lot of work to do, I think, in order to get all of the provisions out of the FAR that run afoul of what this administration believes is unlawful DE&I. And I know we've been talking about this since January of 2025. When is the FAR going to be modified? What is the status of that? I think a lot of people are wondering what is taking so long. And I think maybe the White House is thinking what's taking so long. And so they're putting this again in this executive order. Yes, Nita, I see your.
Well, in fact, I looked, that proposed final rule, the interim final rule, which we do not know what it says, but it was supposed to, yes, exactly. It was filed on April 15th of 2025. And it is still there because I checked today just to make sure. But
Right.
You're absolutely right. There has been, because the truth is you still have to have implementation of the executive order. And that's what this May 25th, where they will issue the deviation to remove, I assume, the supplier diversity requirements and provide interim guidance on the certification provisions.
And the last piece of this I'll cover real quickly because it ties back to something I was talking about before is May 25. So the FAR Council is required to issue deviation and interim guidance to implement this EO. I think that is going to align to the fact that they originally said April 25 as permissible by law to put in the certification. I think you're going to have some contracting officers who aren't going to be able to. I think this May 25 deviation interim guidance is going to give us some additional clarity about how they're going to actually get the certification into certain contracts if they can't be modified. I just, so that way, I think you may end up seeing the certification in new contracts before May, and then existing contracts after May 25th is my take on how that's going to roll out. Let's move on to the next slide and let's talk about some of the key litigation issues. And Sarah, do you want to lead us off on this?
Sure thing. So I think, we've touched on some of these, but it's always good to, kind of review them again in this context, because really the new executive order, I believe as both Liz and Nita have pointed to, really seems to respond to legal challenges that were raised against EO 14173 in litigation that's quite frankly, so it's still ongoing. So a primary concern with 14173 was that illegal DEI was not clearly defined. It left employers unsure of what was permitted, what was prohibited, and really how they were supposed to certify this compliance. So what the new executive order does is really attempts to address that concern by using more defined terminology, by using familiar concepts like disparate treatment to define, what conduct is prohibited. Of course, Liz has pointed out, and I agree, there's still some vagueness there, but they, I think, may have tried to add some more definition, like I said, with these types of terms in an attempt to add that clarity. Challengers of 14173 also argued that it violated the First Amendment by regulating and penalizing employers for their viewpoints or speech on DEI. And so what the new executive order frames up is the government is regulating contractors' conduct, not speech. So really, it could be interpreted now that the government is saying, we're not telling you what to believe and say, we're simply telling you how to perform under federal contracts if you want federal dollars.
Caveat on that is, aren't they telling us how to speak a little bit if we're telling us what we can spend our corporate funds on and what programs we support? I think there's some back and forth on that, and Nita has some thoughts on that too.
Absolutely. And I think that that is another First Amendment problem because, Citizens United was all about what can corporations spend their money on.
Yeah.
And so we have that in our back pocket, obviously. But I think that it was an attempt here. They are clearly trying to clean up in aisle one, as in 14173.
Yeah.
And I think the same thing goes back to the certification, right? We were saying how really there wasn't a lot of guidance about what exact language was required, how agencies were supposed to implement, getting that compliance, that certification from federal fund recipients. So I think what it's done here, it's now standardized the contractual language. It's put it exactly into this executive order. It's more prescriptive. It is given each agency the direction to implement it, and it's given it a deadline to do so. So it's, again, trying to take away some vagueness with respect to the compliance, the certification piece as well. So lastly, I won't have to hammer this home because I think I addressed it earlier, but again, with respect to the False Claims Act and showing that payment is contingent on the compliance with this clause, that's certainly here, right? They've strengthened the enforcement opportunities with respect to the False Claims Act. So
there's also concerns under the APA. And on the next slide, you want to kind of talk through what about the APA?
Well, we live in the world of administrative law, and we have for many years. And the Administrative Procedure Act was described in some of the stuff I looked at as the Constitution of administrative law. And basically what it requires agencies who want to do actions to have notice and comment for the regulations, to have notice and comment under the Paperwork Reduction Act for any forms that they want to put together. And so one of the problems with 14173 was there never was any formal rulemaking. People were preparing these forms for signature based each individual. They were coming all over the place, seriously violating the Paperwork Reduction Act, which requires OMB approval for any documentation that goes beyond, I think, 30 people or 30 entities, which clearly it did. So first of all, I believe that you're going to need some kind of either informal or formal rulemaking prior to implementation. And I think they tried to do that in April of last year, and for whatever reason, they never were able to get it accomplished. And because that regulation was from the General Services Administration, NASA, and DOD was where it was coming out. So it was for the FAR Council. So yes, I think we're going to have some kind of rulemaking, notice and comment, if they want this to actually stand up in court. Because the APA has been used very effectively by both sides against regulations they don't like, or the fact that they don't have regulations. And there's other questions like, is what they are doing, is it arbitrary and capricious? Now, is the inefficiency, waste, and abuse, is that arbitrary and capricious? Is that enough policy reasons? And are the activities sufficiently defined? Is there clear guidance for compliance? I think we can all say that perhaps not as much as you would like. I mean, if you look at, for example, 11246, there's very little there. All of the guidance was in the regulations, obviously, the OFCCP regulations. And so there are lots of upcoming issues that'll have to be resolved either sooner or later around the APA. And finally, and to some extent it's what we've been talking about, is the executive order overextending the government's contracting authority to control the private workplace practices? Something we haven't even talked about is some of the states require us to do things that might violate what is considered to be racially discriminatory. And
So I
so
definitely think the conflict between federal prohibitions and what the state, when you're contracting with state and local, getting state and local funds, that clash is here, and it's going to get only louder, I think, as a result of this. Especially go back to the supplier diversity provisions that many state and local entities do require that in their contracting. And if you have some state and local contracts that require it, but you're also a federal contractor, I mean, are you going to end up being in the position where you have to decide whether you are going to no longer take state and local contracts in jurisdictions that require those kinds of provisions in order to continue doing federal contract work, or vice versa? And that may be the push that the federal government is going for, having companies stop doing work with states and localities that still embrace DE&I.
it's a really good point. Well, ladies, I think it's time to do our takeaways and next steps, because our time, we're doing good on it, but there's a lot to cover here towards the end. So Liz?
Yeah, okay. So the first thing we put in here, and I know I've beat the dates here, but I think it's really important that the executive court order came out on the March 26th. By April 25, to the extent legally possible, contracting agencies are going to be putting these contracts in, putting them in, whether that's in new proposals, if it's in new contracts, whatever the first rollout of that is going to happen prior to April 25. By May 25, you're going to have FAR Council issuing guidance on how to do deviation. So if you have existing contracts, you may not see the contract provisions coming in until after May 25. There may be some guidance on the implementation of that's going to come out by FAR. But the pedal to the metal come May 25, because by July 26th is when each contracting agency has to complete this, review their completion, and report to the White House about how complete they have been. So it's coming. And I know we recently, we've said before the others were coming, we'd seen them trickling out. I think we're going to see a floodgate of these certifications. Hope you enjoyed the spring. So Sarah, I kind of took away the first of your key takeaways on the next slide. I took the first one, but what else we got?
All right, so beyond everybody needing to be prepared for these new contract clauses, the second thing I think that you want to take away from today is that we are certainly seeing increased responsibility on prime contractors. Primes are not just responsible anymore for their own compliance. They're really expected not just to monitor, but even in some instances, report on their subcontractor compliance. And that really has now expanded, all the way down that supply chain. That's a lot more responsibility on primes now. Again, at the same time as all of this extra oversight, you're also now increasing your exposure to False Claims Act liability, because you are now not just saying you're also in compliance, you're certifying to your own compliance, you're pretty much certifying to monitoring your subcontractors' compliance. So those two kind of work together, of course, to really create a lot more responsibility. And I think last takeaway worth taking away, this is not going to be siloed at each contracting agency. This is a coordination across all contracting agencies, as well as those central policy authorities like the White House, and also enforcement authorities like the Department of Justice or EEOC.
Right. I think that's the real, it used to be, I think contractors would be, if you are not in compliance with your 11246 obligations or affirmative action, if there was disparate impact or treatment in your hiring and selection personnel activities, it was handled by OFCCP, the Division of Department of Labor. Labor's not mentioned in this. And I think we need to, hadn't kind of focused on that yet, but it's not a focus of this. So each contracting agency is going to do their audit investigations, find out if they think there's problems. It rolls up to Attorney General, FCA compliance, EEOC, right? I mean, so I think the potential weight of a violation and the enforcement mechanisms that are going to be coming down on you are much stronger than what we used to be worried about if it was simply an OFCCP audit or investigation by OFCCP. And
And
yeah,
I think
Nita.
yeah, and I think before we jump to the next slide, I think you're already seeing that with EEOC. For EEOC in particular, is engaging in subpoena enforcement actions
Yeah.
demanding a great deal, the Nike case being the most prominent one, where they're putting into this subpoena enforcement action all of the information that they have and demanding more. So basically all the information that you have around hiring and promotion. And I think that is going to put a great deal of pressure on federal contractors to comply with this. And to be honest, they always wanted to comply. Most contractors wanted to comply with their obligations.
Absolutely. So going to the next slide, and Nita, I mean, taking all this in one slide or less, how can contractors be prepared for this? And actually, and I will heighten it's not just federal contractors because of the. I think we need to be taking the lessons on how this administration is going to be enforcing for all corporate entities. They always test drive everything on federal contractors, but this stance and how they enforce on federal contractors will also be instructive on private sector as well.
Absolutely. And that was part of 14173, that they
Mhm.
definitely said, we're coming for you too, basically, in so many words. But
Correct.
back to your point, federal contractors. And I mean, I think all employers, all private employers need to look really hard. They're drilling down. Let's take an EEOC example. EEOC sued a Coca-Cola distributor who was had some kind of a women's networking meeting, saying the women got paid, they got to go to this casino, they got networking with the execs, and the men did. So that's a lawsuit right there. So you need to look at all your DE&I programs and policies, look at your hiring, promotion, and compensation practices. And Liz has talked about this supplier diversity. This is going to be really tricky because you have right this minute supplier diversity obligations under your contracts. What are you going to do if when they put in the new FAR, I guess
Mm-hmm.
saying you can't have chosen those people based on them being minority owners of
All right.
organizations?
Yeah.
And I saw an article today, they're already people are being fired because they were part of the diversity program, part of that supplier diversity program. That,
Vendors, yeah, yeah. So we're also going to be looking at, I think we need to do regular assessments of your DE&I program. I know most of you out there have already done that, but I think taking a fresh eye and looking at going back through in the work that you did when the first EO came out, maybe dust that off, Do you need to sharpen your pencil? I know we used to kind of say red, yellow, green, right? And where was that level of risk that you were comfortable with and you were able to keep those programs? I think we need to sharpen our pencil and look at those a little bit more.
And also because within the contract language, the contracting agencies come in and look at records at any time. You're also going to make sure that you're looking at it a little bit more frequently to make sure that, and again, it doesn't have to be every day, but you don't want to do it a little bit more regularly given that potential.
Well, hopefully the FAR language will give some more specific guidance around some of those areas that we've talked about which is unclear. I mean, that is what the implementation is supposed to do so that you know as best you can what is going to be allowed and what's not. It's important to remember that this administration believes, and if you read the first couple of paragraphs of this executive order, they believe people are hiding DE&I and they're determined to flush it out of the system. I think one last thing before, and then everybody can go around one more time. Uh, this thing that Sarah has talked about and Liz has talked about identifying your subcontractors and how are you going to assess their compliance, because you're going to be held on the hook to know what they're doing or to be reasonably knowing of what they're doing. And how are you going to do that with all the contractors, subcontractors you have? Ladies, anything else? We got a few minutes here just to kind of wrap up before we close this webinar.
I think there's a lot in this executive order. I think there's a lot that's still unknown. I think the one comfort that I still have is that Title VII and the other federal anti-discrimination laws are still the law of the country. I don't believe that this executive order on and of itself can make vague statements in Section 3 unlawful conduct without us having a clear definition and understanding of what they're going to be deemed as unlawful there. So I think there's has to be some clarity here. If you're grounding your practices and policies in compliance with federal civil rights laws, so the federal anti-discrimination laws, I still think that is the safe place where you can continue with your policies and procedures.
And I agree with that. Well, I think we're at the end here. I think we're going to see Sarah in just a minute. Can I go to the next slide really quickly? Just wanted to remind you that we do have the DC Insider podcast, and I know that we will be doing a podcast as we get closer to this. And also, we have a DE&I webinar coming up, which I believe will be on April the 9th. Sarah and I will be on that as well. Because there's so much to talk about around DE&I. We're not going to dig as much into this, but more the other agencies. What are they doing? And so thank you very much for attending this webinar. And Sarah, you're up.
We'd like to thank you all for joining us today. If you have any further questions, please email us at info@fortneyscott.com. A recording of this webinar and a copy of the PowerPoint will be available to all those who attended. This will be sent as soon as the webinar recording is available. Stay tuned for our next podcast and webinar.